Welcome everyone. This is the third session of the Ibis Prep Florida Essentials course, and it's officially May. So everyone got to post their Justin Timberlake meme today, or I guess yesterday, and let us know that it's May, and we now have the July bar exam coming around the corner. And we are going to have an amazing lecture today. I'll be teaching about Florida constitutional law and Florida property law. Florida con law is very difficult because it includes the Florida Constitution, the federal Constitution, and also con crim law, which is Fourth, Fifth, and Sixth Amendment considerations like search and seizure or warrants and things of that nature. So con law can be difficult, and real property, everyone knows, is not an easy subject. So pay attention today, but remember, we're going to go over all of these subjects in detail over the complete course, which starts May 13th. The Essentials course is just here as a introduction to get the wheels turning and to give everyone a head start compared to the other students. Your assignment was to submit 2 essays, a contracts and a torts essay, and then after this class, they'll be posted the essays for this week, which will be a con law and a property essay. And then for the final week, the assignment will be to do the Florida multiple choice questions. So I know I could be a little bit much with all this, assignments and, the difficult things to hear, but I'm going to turn it over to Sam, who will be a little more pleasant.
Hey guys, good evening, everyone. It's Sam, your fairy bar mother. And like Andrew was saying, this is our last bar exam. Every time I talk to a client, I always make sure that before we get off the phone, I always make them say, this is my last bar exam. Your words are so powerful, especially when you say them out loud. And I have a few affirmations for us tonight, so I can't wait to share it with you guys. But Drew, can you enable screen sharing for me, please?
I can do anything, including enable screen sharing. Done. It's Professor Drew, by the way.
Sorry, Professor Drew. I'm so sorry.
I'm just kidding.
Okay, guys. So let's hold on.
So last administration, what was tested was defamation, which is interesting because it has constitutional considerations, right? It's a tort, but why does it have constitutional considerations? Because there's a freedom of speech. And as we know, defamation is not one of the constitutionally protected types of speech. It's like words likely to incite imminent lawless activity or hate speech or fraudulent commercial speech or defamation. That was a good segue. Back to Sam.
Okay, guys, welcome back to the Florida course. I just wanted to check in with everyone and see how everybody's adjusting. I hope you guys are using this course as a pre-game to bar studying, trying to adjust your schedule, trying to figure out when's the best time to study, trying to figure out how is the best way to study. So how is everyone adjusting? Has anybody began to get into a flow? Does anybody have specific things they're going to do for studying? Does anybody would like to share if you guys had made any adjustments? Anybody? Or does anybody need any suggestions? Like, do you guys know exactly how you're about to tackle studying for the Florida bar? Other than, of course, using our assistants, right? Because it still has to be personally tailored to you, right?
So I'll jump in and I'll say that my schedule is so ridiculously crazy that I actually told Andrew today that I will just fit in the Adapt2Bar app wherever I can. And if that's in between meetings when I'm running to the bathroom, take my precautions like while I'm doing that. Just because I work anywhere between 60 to 80 hours a week to begin with.
Oh, wow.
So it's crazy, but it is what it is. And I try to kind of find the time to block off just for that. And if it's not on my calendar, it's not going to happen. So I will literally schedule it like a meeting on my calendar to have that time.
No, for sure, for sure. I can definitely give you some tips as a mom that was working. The best thing to do when you're studying is try to prepare the day before. So if you know that, like, so tonight, get everything you need for tonight, for tomorrow together tonight. I would print everything out. I would know exactly how many questions I'm doing, exactly what subjects I'm doing, have my to-do list written out before this evening is done. So then in the morning, I could literally start as soon as I can. Sometimes I wake up earlier, sometimes I didn't. Sometimes I would do a few questions with my coffee or with my breakfast. And so, you really want to literally breathe the bar exam. A lot of times that sounds overwhelming, but it really isn't. Because again, like I said, this is material that you guys have already learned, right? We're just getting in a motion where we're reviewing it so well that we're going to pass this exam, but it's nothing new. These are things and topics that you've learned. So there's nothing to be intimidated about. It's just about going through the steps and doing everything that you need to do. So I would literally have everything set up, everything ready, my essays, because I used to like to study with paper. The essays, they're gonna give it to you on paper, even though you type it. MBE is definitely a printed test. So I didn't mind having things with me. So if I was going to an appointment and I could, I had a little 30 extra minutes, I was there doing my MBE questions. And once you make it a part of your lifestyle, it becomes less overwhelming because it's not like, oh my God, I'm studying for the bar. It's, oh my God, I'm living my life and, I'm about to be a boss attorney. And, just like an attorney does, you're going to have to be, attorneys are typically on call all the time. It depends on what type of attorney you are, right? But there's always emergencies, there's always things going on. So it's just like getting adjusted to just not stressing and just doing your tasks for the day is a great way to start bar prep. So then you won't have to sit up here and be so overwhelmed and worried and like, what am I going to study? Da, 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 da. You don't have to do that. Plan a day ahead, have your things printed out. So no matter where you are, you can do them, and make sure that if you had 3 tasks for the day, even if you don't get through all 3, tackle that last one the next day. Make sure you add it on your next to-do list. Just keeping up with everything that you need to do. Last night we spoke about balancing Florida and MBE. So I'm just going to reiterate again, if you are taking both, be cognizant of how much time you're giving each test, right? They each are very, very selfish and they both want a lot of your time. So make sure if you can, try to do one day Florida so you can keep your mind on Florida, and then the next day MBE so you can keep your mind on MBE, because we know the tests are completely different. So we want to make sure that we're keeping all the concepts on the right days so all the information can flow. It's May, right? So I know I've seen a lot of people say, oh my God, I got like a 56 on my Florida multiple choice. And it's like, should I be worried? No, it's May. Please don't worry yourself about your grades. This is more about focusing on issue spotting, understanding the concepts, and identifying the concepts, okay? Knowing what's going to be on the exam and making sure that you have the information that you need to learn the information, making sure you have your outlines together, et cetera, et cetera. Again, here I'm going to share my score. I got a 141, right? So the goal for the essays is try to at least get a 50 on each essay. Like I told you guys before, contracts, common law, and torts are something that's tested every administration. So I took advantage of that and I made a poster board for contracts and torts. As you can see, it kind of reflects. I got a 73 on my contracts exam and a 68 on my torts exam. I was not prepared for criminal law. I knew a little bit, but I thought they tested it so many times and weren't going to test it again. But because I did so well on my first and third essays, I did pretty good. And it even helped me on my Florida multiple choice. Florida multiple choice has been a problem for me for decades. I hate multiple choice, period. And Florida multiple choice are so specific that it's like, if you don't know the rule, if you don't know the little nuance, you're going to get that question wrong probably, right? But I still held up 15, 17, and 16. So you want to stay in the 15 to 17 range usually to get a good score, to hold your score heavy, because they're gonna average everything and they do their own little magic math, and the only way to keep it going in a positive direction is if you make sure that you have, I don't want to say aggressive scores, but scores that keep up with the curve, right? You can't be below average. You have to literally be on average or above. So practice every subject of multiple choice. There are only a few subjects where they tell you that are for sure going to be on the bar exam. Florida rules of civil and criminal procedure, that is a subject that's going to be on the bar exam every time. So that's a subject that you should give a lot of love to, because for sure it's going to be there and you want to capitalize on how many points you can on those areas. We kind of did a essay review last time when we did a practice essay. So I just want to reiterate exactly how you should be tackling your essays. For the stage 1, you always want to read an issue spot. After you read about 100 Florida essays, you're going to see that it's usually the same thing. All the torts, it's usually somebody getting hurt, somebody eating something, or or a product liability issue or a defamation issue. So it's really repetitive. So once you read about 10 to 15 torts essays and you issue spot them, you should be able to read an essay and without even looking at the answer, identify what they're asking you. And the sample essays are not perfect, right? But they show you how many issues you really need to grasp. Sometimes you won't get enough points because you missed out some issues. If it's torts, even if it's not an intentional torts issue, 9 times out of 10, you can fix it in there to add battery and assault. That's always a wonder. Hey, the issue is whether Sam committed an assault against Andrew. And from there, you could sit there and say, yes, under these facts, no, he did not, but you still gave them the rule. You still told them what an assault is, etc. So make sure you're getting all the points that you can. And the way you do that is by making sure you can identify the issues. So read enough essays so that you can identify the issues, and then you can go to memorizing everything. Step 2, you're going to outline, right? You need an outline that you can memorize. Just like Jacob made that whole outline, and I 100% agree with Drew that I think it's best that you make it yourself. Because when you're making it yourself and you're reading what you're writing, it hits you that you don't understand sometimes what you're writing, especially when you're trying to attach it to a hypo or a practice essay question, right? So you're like, oh my gosh, so an assault is an apprehension of battery. Like, what does that mean? That means that you're scaring the person, that they think that you were going to hit them in that exact moment. But until you can write the rule out and understand what you're saying, even if you read somebody else's outline, it's just going to be words. It's not going to have no meaning. So please start starting your outlines, especially with the questionnaires. They are perfect starting points for your outlines. That's what I use to memorize my rules. And I'm not going to lie, I wish I had more time to devote to all the memorization. I probably could have got a little higher on my essays, but I promise you, they will not lead you wrong. They have all the highly tested issues on there, even issues that are not highly tested, but if they show up on there and you can know it, boom, that's extra points that the average bar taker is probably not going to know. And that's one thing that I love about Andrew's program, is that he gives you what you need to know. And a lot of times when you're taking an exam, you're like, oh my gosh, is this enough? Is this enough? And it's like, he gives you enough. He's going to give you enough work to digest everything, but just make an outline that you can memorize. Like I said, start with or make sure it look like he has some type of, so don't just steal Jacob's or somebody else's, use it as a reference, but also please make sure that you're making your own outlines. Step 3 I have for analyze. Is this a subject I need extra help on? Is this a strength or weakness subject? So we're not all going to be good at everything, correct? So we're going to look to ourselves and do some introspection and realize, okay, torts is not my subject. I really need help on torts. Or contracts is not my subject. I don't understand how to apply UCC and how to do the merchant rules, et cetera, et cetera. You have to know what you don't know, or it's going to be really hard for you to actually do well on this exam, because it's like, if you don't know it, then you're not going to put on the exam and you're not going to get points. So you want to make sure you're getting all the points that you can. I think the essays are the easiest portion of the exam, mainly because, like I tell you, it's so repetitive. All you have to do is review the essays that they gave you already. They gave it to you for free. It's online. You can access them anytime you want. And if you just have to memorize those, I think that's the easiest. You're not memorizing a whole subject. It's like you're memorizing just the subjects that they only test, because on essay, they can only test a certain amount of things, and the certain things on multiple choice, they can only test, So try to go through at least 10 years. So we're 2024. Try to go all the way back to at least 2014 and read all the essays you can. Read an issue spot. Don't look at the answer. Read it and give it a good issue spot. And then when you read the answer, be like, okay, did I issue spot everything? What issues was I missing? Because you don't want to miss these issues. You want to stay on top of the curve, and you want to make sure that you're at least keeping up with the average bar examinee. And another thing that I've been noticing with Florida is that they have been testing a lot of federal law, right? They're doing torts, they're doing contracts, they're doing con law, they're doing crim law, you know, and they just want you to be able to know the federal law and add in our little Florida rules. In Florida, a contract is da 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 da. You know, you have to make sure you give them the Florida goods, the Florida sprinkles, you know, because that's what they want to see. They want to see that you know the federal law, and most importantly, you know Florida law, because we are here in Florida and you're going to be a licensed attorney in Florida. So as for our mental health awareness, we're going to do some affirmations this week. I know affirmations seems kind of corny, but I think ever since we were a kid, you know, they always said, if you could put your mind to it, you can do it, right? Your words are so powerful. So a lot of times we don't realize the things that we say to ourselves in our head. Like you'll talk to somebody, especially venting about the bar, and you might catch yourself saying things like, oh my God, this test is so stupid. Oh my God, this test is a scam. Oh my God, they're taking all my money. Oh my God, I'm never gonna find a job. Oh my God, I'm never gonna pass the exam. Like those things are horrible for your mental state. And it's horrible for you doing bar prep. So you have to learn that when you are saying these things, you need to pivot and say something better. I have 8 things that you can say whenever your mind is going on a tangent. I will pass the bar exam. The bar exam is passable. There's many people who pass the bar exam. I know they give you the numbers and they scare you and it's 39%, it's 28%. I understand, but the bar exam is passable. We all know somebody who passed the bar exam. Okay. And sometimes people be like, oh, you have 5 kids and I don't have any kids. How did you pass the bar exam? Because baby, I'm telling you, no matter what you have going on in your life, the bar exam is passable. All you have to do is give it the time and the effort and use the right tools and you will pass the bar exam. Number 2, I can issue spot and write essays well. This is very good for your essay writing confidence. You know, a lot of times when you're trying to write your essays, you're thinking, oh my gosh, how do I even start this? What am I supposed to say? How am I supposed to write? Just keep in your mind, I can issue spot and write essays well. And that's the bottom line. Don't give yourself a hard time. It's May, like I said again, remember, we're starting slow, but you're going to get the help you need here with Ibis Prep. So please don't be too hard on yourself. Just show up and do your best. 3, memorizing is easy for me. I know memorizing can be a little intimidating. You're thinking, how the heck am I going to memorize all these subjects, all these rules? And it's like, you'll be very surprised that after a really good review and you sit there and memorize, it's going to start building. Like there's just certain things that become a part of your brain that you'll never lose, because as an attorney, these things are going to repeat, right? You're going to be in certain cause of actions where these rules are going to come up. And when you keep repeating all the rules and you keep making sure you're keeping up with your homework and you're practicing essays, it's all going to be repetition, repetition, repetition. So when you're going to memorize, it's not like you're memorizing from scratch. You're memorizing from your retention already. So memorizing is easy. Like that's going to be the easy part. You don't have to worry about if you're going to be able to memorize all this information or not, because you will. 4, I have the tools to pass the bar exam. You do. You have the tools to pass the bar exam. You have a chief, a professor, Drew, who is here for you guys. And of course, the rest of the Ibis Prep staff. As long as you have the tools, you could build any house, right? You have the tools. I am a hard worker. This is a big one, because a lot of times we think we're failing because we're not doing good enough, or because we're not productive enough, or et cetera, et cetera. You are a hard worker. Give yourself that. Pat yourself on the back. You know how hard it is to not only make it through undergrad, then go ahead and take the LSAT, and then go through law school, and then go through the bar exam more than once? Do you think weak people do that? No. That's a boss, okay? That's a hard worker. That is somebody who is devoted. You have to build yourself up and understand that, listen, you are a hard worker, and again, you can do hard things. The bar exam has nothing on you. You are on the right path. I know a lot of times we're like, oh my gosh, why did I decide to do this career? These people tried to warn me. They told me since law school, don't do it, don't do it. And I still did it. And then we're like, oh my God, am I on the right path? And I honestly believe that everything happens for a reason, you know, and sometimes through failure, we learn so much about ourselves, and we learn so much about our limits and how far we can really go. So don't take failing the bar exam as saying that you know, you're not in the right spot and you shouldn't have went to law school. I really don't think that if you weren't supposed to be an attorney, that you would get this far and then be like, okay, I'm on the wrong path. Like, I don't think so. I always believe that no matter what path you choose, you're always going to end up where you're supposed to be. Okay. Last but not least, my favorite affirmation is I will be an amazing lawyer. This is so good to repeat to yourself over and over, mainly because a lot of times when we're doing these things that don't have nothing to do with practice, I wouldn't say the bar exam has nothing to do with practice, but you know, this is not how we practice. We don't just practice from memory. You know, we do research, we take our time, we have deadlines to figure out all this information. We don't have like a 3-hour slot to help a client, right? But at the same time, you could still be a good lawyer even if you're not a good test taker, right? You can still be an amazing lawyer because you're compassionate, because you like to help people, because you have great research skills. The bar exam does not test your research skills at all. But that's a big, big part of being an attorney, right? Is being able to research an issue and find out what the answer is. So I just want to encourage everybody to know that you're not only on the right path, but you will be an amazing attorney, despite how many times you took the bar exam. No one's going to ask you in the future, how many times you take the bar exam? No. As long as you have your bar card and your bar number, that's it. Okay. This bar exam experience is going to be a time of the past. And the only thing that I hope you guys can do in the future is help somebody else. You know, when somebody helps you pass the bar, I know a lot of attorneys, they just go on to their attorney life and they're like, forget about it. But, you know, let them know, hey, try this company. Hey, this is what I did to pass the bar, you know, because we're all in this together at the end of the day, and we all need each other. We're not here by ourselves. I want to say thank you guys for your time. Again, I'm your fairy bar mother, and please call me, text me if you need me. Literally, I am here for you. I've spoken to a few people and I love when you guys reach out to me, mainly because it's just like so many people are so shy about expressing themselves in this situation. Like they don't want to talk about themselves failing. And it's just like, you did not fail at life. You failed that one exam, but you did not fail at life. And on top of that, like I told you, you cannot be ashamed of being an attorney. Like that's like saying you're ashamed of trying to be a millionaire. Like, why would you do that? Right? We're all here for one reason, and you can do this. It's an exam that wants you to memorize things. We know how full of crap it is, right? But it's beatable. It's 100% beatable. And even if you didn't get it last time, even if it was by a few points, you will get it next time. Okay. I've always seen our students have more than 10, 20 points increase. Like statistically, if you had like, let's say you got a 118, they're not expecting you to get a 136 on your next try. You know what I'm saying? They're thinking you're going to go up maybe another 10 points. But with our program, we don't do that. We really show you what you need to do to expand your score, to get it as high as you can. And all you can do is do your best. Okay. Again, I'm so happy to have you guys here. Don't forget to text me or call me if you need me. If you guys have any issues with the homework assignments or accessing the drive or anything, or the Google Classroom, I am your girl. Andrew, are you ready? I feel like your son is,
This
he's
is
having a
actually,
moment there.
this is my fairy dog mother right here. This is Rosie. This is the fairy dog mother. No, we're good. Always good. Amazing presentation, Sam. You bring the vibes and you let people know that, you know, I love boxing, so I always relate it back to boxing, but it's okay to lose a round. It doesn't mean you lost the fight. It's okay to get knocked down. It doesn't mean you got knocked out. And for those of you who are taking this for the first time, you know, you want to come in there and learn from other people and say, what can I do to ensure that this time will be a one-time only endeavor? I have had extreme success with the Florida bar exam, specifically part A. That's something that I think I have down to a science. I have the Florida multiple choice question bank that I want everyone to do multiple times until, you know, you can get every single one of them correct, because why not? And, you know, we'll continue to provide materials. When it comes to the essays, you want to memorize the Florida questionnaires so that you can recite the points of law on your exam. I had a student whose essay was republished as the model answer. When I took the Florida essays, Alex was her name. To be fair, she was a practicing personal injury attorney in Connecticut, and it was the torts essay, so it was very much up her alley, but credit is credit. And you know, I know how to write great essays. I'm gonna really harp on essays. That's why I assigned 4 for this essential course, because essays are the one piece of the exam where you can really get a really high score. Like you saw, Sam scored in the 70s on a contracts essay. That's incredible. You know, a passing score is 40s, 50 is nice, 60 is good, 70s is really good, 80s is phenomenal. 90s, they'll probably invite you to grade. And then multiple choice is just very difficult. A lot of people do average or slightly above average or maybe struggle. It's like MBE. It's just a difficult experience because each question is an island and you have to think critically and consider why some answers are wrong and some answers are right. And it's a difficult, annoying process. But essays, you can really control the environment by memorizing the rules of law, being a seasoned issue spotter, and then just following a consistent formula. IRAOC, issue, rule, analysis, opposing argument, conclusion. Opposing argument helps you get more points by saying, hey, if I'm wrong, you know, this is what the other side would argue. Let me not put all my eggs in one basket. So we're going to write in that sweeping style. Like I said, it's sad that a lot of my students aren't here from last administration because they passed. They had amazing results. And that's what I expect this administration. One of those students, I told the students before class, was Jacob. Scored above 150, and this is his master outline. It's an 81-page outline. I've given everyone access to that. You have my essay guidebook I've shown everyone, and you have all our video lectures here that you can access. These are all the videos that we've done, including these 1-minute TikTok videos. This could be kind of cute. Why don't we start today by talking about Florida con law or Florida property? What do we want to do? Let's do Florida con law. Let's see my ugly behind. Just 1 minute, don't worry. Con law on the Florida bar can be very tough because it can be either Florida con law, federal con law, or con crim law. When we're talking about Florida law, you want to make sure you understand the homestead exemption. We will protect a homestead within a ½ acre of a municipality or 160 contiguous acres outside of a municipality from judgment creditors, except for taxes and mortgages, liens, and other encumbrances on the home. We also want to know the sunshine law, which means that all public meetings and conversations must be in the light and there's a public right of access. Federal law, we want to know things like the Commerce Clause, equal protection, and due process. When it comes to con crim, we need to know about 4th, 5th, and 6th Amendment, specifically Miranda rights, the exclusionary clause, and the fruit of the poisonous tree doctrine. Okay, cool. That's all you need to know. Class is not law on the class is over. Everyone can have a no, but these are some 1-minute videos that I did that might be helpful. And then you could also go into my complete lecture series. You could see all the videos I did in July. You could see the you can see a lot of the videos there. That's in the complete lecture series. One last thing that I'll show you in the Florida complete lecture series, if you go into Florida essays, perchance, and then let's say you click Florida contracts, the videos that just have a background of like a picture I took, let's say, those are good. They're just me. It's just me talking to the screen. Whereas some of the other videos are like this. They're in class, so they might have slight interruptions or they might, you know, make jokes or whatever. But the ones that have like just pictures in the background are pretty straightforward. I would recommend watching all these videos. And I also like Grossman's What's the Issue videos. I like YouTube as a means of just Googling things. You'll probably find a lot of my videos. But I think the more the merrier. If you're an auditory learner, you know, watch these videos. If you like learning by reading, read my book. I think both of those things are kind of essentials, right? That's the point to this learning experience. And now we've added the master outline by Jacob that you can kind of peruse through. Your assignments you saw, you have 2 essays that I hope everyone writes. You could see only 4 of the people have written the essays, but don't worry, I'm not like mean. If you write them, I'll grade them, and it can only be helpful. The recordings from the first classes are here, and this is a recording live of the 3rd session. We're going to jump into one of our favorite subjects, which we said was con law. And I really like these blue PowerPoints. I particularly like these blue PowerPoints. The guy who made them is one of my favorite people. No, I don't know. I made them. I'm not trying to be that like cocky. The guy who made them is me. Okay, so can we see them? Yes, we can. All right, let's get it. So con law. Eric, are you feeling good? Yeah, I just saw you feel like, con law. I hear you, but it's not that bad.
No, to be fair, my daughter was also calling to me at the same time. So that's you
Okay,
caught me responding to her.
No, but that's the vibes. Like con law is not that fun. I can casually ask someone what are the first 16 amendments to the Constitution. If they're taking the MBE, I need them to know that. If they're taking Florida, I at least need them to know First Amendment inside and out, Fourth, Fifth, and Sixth, certainly. And then I would say 10th, 11th, and 14th. So pretty decent amount of them. You want to know the amendments to the Constitution. That's fundamental. Kind of a joke, right? Fundamental rights. Okay. That's me, my grandfather, my father. I'm a third generation graduate of the University of Miami. I teach for a lot of things. I think I should rewrite the Constitution because I don't know, it's a pretty old document. I think if we took a fresh approach, it might be nice, but that might be controversial. Okay, so our business, we're booming. Our vision is to keep going. Mindfulness, right? Mindfulness versus meditation. I like that image. Take a moment to meditate on it. I'm just hilarious, right? But I do like that image. It's cool. Okay, study strategy. Don't compare yourself, right? Everyone in here is on a different path. It's a marathon, not a sprint. Consistency and regimentation are keys. Focus on memorizing the rules of law. Block out all distractions and focus. I want to shout out Angie if she's here. She is. She was supposed to go to a Heat watch party, but is specifically here studying instead because she recognizes the test is around the corner and, you know, days are limited. So props to that. And I told her that the Heat aren't looking too good anyway. Not to like hate on the Heat. Let's go Heat, but true facts. Okay, so 2 timed essays per week. That's what I recommend. That's how the course is started. Once my complete course starts May 13th, I want everyone to get in the habit of writing 2 timed essays per week. I am by one singular account, right? By my own account, an athlete, right? Like got my punching bag right here. See, athlete. And the way to prepare for sports is like practice, right? Like if you're gonna play in the basketball game, scrimmage. If you're gonna run the track meet, you know, run the race, right? That's the same concept here. You're gonna be writing essays. So what should you be doing primarily? Practicing essays. If that is a tough pill to swallow, it's not supposed to be easy. But if you want to guarantee that you're gonna pass this exam, I say minimum of write 20 timed essays in practice. Because if you do that, then writing your 21st, 22nd, and 23rd is going to be a lot smoother. I have a student right now I was working with today. She's brilliant. She knows her stuff, but she admitted to me, I struggle with timing. You know, I'm running out of time. There's only one way to address that. Practice essays under time conditions to really, you know, train yourself. It's like you got to focus on accuracy first, then speed. You know, you got to walk before you run, proverbially. All right, cool beans. And yeah, complete all the multiple choice questions in the on the interactive Q bank. See, this needs to be updated. In the past, it was on the drive. Now I can do it in the Q bank. Okay. Read the call to question, active issue spotting, notes, highlight, headings, abbreviate, uniformity, make it obvious, like buzzwords, no recitation of facts, be Florida specific. In Florida, right? All you New Yorkers who are coming, no offense, Erica, but all you people from New York or New Jersey who are coming to Florida to take this test, and you know, they don't really like that. They make it hard. They make it Florida specific. So if you know the New York law, it's not actually going to help you too much. I mean, it'll help you, but it won't carry you on the Florida exam. You need to know Florida specific rules. Don't rewrite rules. You're not going to get points. It's great on a rubric system. Say a rule, get your points, move forward. If you got to restate it, say as stated above or infra or supra. Don't ask me which is which. I always forget. All right, tip. If there's a separate rule, make it a separate IRAC. Issue, rule, analysis, conclusion, right? The issue is whether there has been a violation of Tommy's First Amendment rights. Rule is in Florida, right? You have the freedom of speech, freedom of religion, freedom of the press, freedom of freedom of petition, and freedom of assembly. Here, XYZ. Right? I'm just giving you an example. And then the next issue could be, additionally, Tommy will argue that the ordinance violates his Second Amendment right to bear arms. I don't know, probably wouldn't be that, but just something, and you would give it another rule analysis conclusion. So is con law tested often? The answer is yes, it's tested super often. And that's why we really need to know it. This hasn't been updated in like 2 years, but they've been testing a lot from my observation. Con crim law, which is fourth, fifth, and sixth amendment. I'm gonna play this game right now called Pop Quiz Hot Shots. Can anyone tell me what is guaranteed by the Fourth Amendment of the US Constitution?
Due process.
Right against illegal search and seizure.
Let's go for illegal search and seizure, right? Reasonable expectation of privacy. And in Florida, you have a heightened right of privacy. That sounds like a trivial fact. It's not. You can get a point on the Florida bar exam for stating that simply, that in Florida, there is an express heightened right to privacy. In Florida, we protect individual rights of privacy. You're literally allowed to shoot someone if they're threatening you, the stand your ground laws, right? But a heightened right to privacy. So that's something to consider. I said before the recording started that defamation is heavily tested, as it was most recently, because it implicates torts. It is a tort, but it also implicates the First Amendment. Privacy is another one that has that implication. It's a tort, right? Invasion of privacy, but it also implicates that heightened right to privacy in Florida. So you could see con laws tested often. Someone out there, genius, knew what the Fourth Amendment is. Now, does anyone know what are the 5 things tested on the Fifth Amendment? What are 5 pieces of the Fifth Amendment in general? Does anyone know 1 or 2 or 3 or 4 or 5 even? Yeah, Angie saying Miranda. Nice.
Right against self-incrimination.
Right. If anyone's ever watched the Dave Chappelle skit, I plead the fifth. So you're right against self-incrimination. And Miranda rights, just to clarify, your Miranda rights are your right to an attorney before adversarial proceedings have begun. When you are in custody, let's say, your, right to remain silent, your right to have an attorney, and if anything you say can or will be used against you. Those are the Miranda warnings, but your Miranda rights essentially mean your right to counsel when you're in custody. And we also have your right against self-incrimination. I plead the fifth. Does anyone know what else is covered on the Fifth Amendment? Double jeopardy. Fantastic, right? Your double jeopardy rights. You cannot be tried for the same crime, held for life or limb for the same crime twice. So that is the criminal version. Does anyone know what it's called in Civ Pro when you can't be charged with the same thing twice? I'll accept 2 answers here. And nice, Angie. But I know I'm throwing a curveball. Yes, claim preclusion. Good job, Pablo. Claim preclusion. And now for the double whammy bonus point and 1. My next question, does anyone know the squares of the Heat game? But does anyone know what claim preclusion is also called?
Res judicata.
Nice, res judicata. See this, the more you know, right? The more you know, the better you'll do on this test. I want to turn everyone in here to super masterminds. And sorry if I'm bothering anyone by standing up. I'm trying to appease my Jack Russell right now, who doesn't like me when I sit. Okay, so we have claim preclusion, which is res judicata in civil Civ Pro, let's say. But we're focused on the Fifth Amendment, which is the criminal version, which is your right against double jeopardy. So we've remembered 3 things from the Fifth Amendment so far. Your Miranda rights, which is your right to counsel, your right against self-incrimination, pleading the fifth, and then we talked about double jeopardy, your right not to be charged with the same crime twice. Then Angie, who is here and not watching the Heat game, is talking about due process. I love that. Due process is indeed the answer. Due process is a very important one. Due process, there's procedural and substantive due process. So procedural due process is your right to a notice and hearing. They're not just going to impose liability on you or criminal liability on you or anything. That you have to have a notice and hearing. That's procedural due process. Substantive due process means you're not going to be deprived of a substantive right. It's a law is not going to deprive everyone of their right to, let's say, access courts or they're just freedoms and liberties. So due process could be substantive, procedural. Those are the 4 things. And then does anyone else know Anything else covered on the Fifth Amendment?
The takings
Taking,
clause?
Nice, the takings clause, right? There can't be a taking without just compensation. Excellent. We'll think of that also. When there's a takings, it's, I'm trying to think of the other word. It's
Eminent domain?
yeah, eminent domain, and there's another word. We got no other words. I've first time in my life, I'm blanking out right now. Eminent domain and condemnation, right? Inverse or regular condemnation. These are all things that are associated with takings. When the government takes property, and you could have a physical taking, which means the government actually takes the physical property, or what's known as a regulatory taking. And a regulatory taking is some government act or ordinance or regulation essentially deprives the owner of the investment back expectations or the economic viability of their property. So that's a regulatory taking. Pretty cool thing, right? That Fifth Amendment. But I'd like everyone to just, maybe jot that down. I'm sure I'll cover it on a subsequent slide, but that's just kind of something to learn today, right? 5 things you should know about the Fifth Amendment. Those are due process, takings, double jeopardy, Miranda rights, and your right against self-incrimination. Everyone learn that? I can retire from my job now? Okay. How does defamation implicate the Constitution? Private cause of action versus state action. Okay. The reason why is because on these essays, like I said earlier, you're going to argue both sides. So Tommy will argue that Johnny defamed him by saying he was an ugly faced meanie pants or whatever. And then the person will defend that it's his constitutional right to freedom of speech under the First Amendment. However, this argument will likely fail because there are certain types of speech that are unprotected, including defamation. You could also say truth is a defense to defamation, whatever it may be. But I'm just saying there's implications to it because of the defenses. That's something that I want to train everyone to do. Whenever you have an issue, you should also have a defense kind of lined up, right? Something they love to talk about on Florida essays, and we'll probably cover it soon, is the Sunshine Law, the right of access. Well, the immediate defense you should argue.
Leave it, Bruno.
Yeah, Bruno, leave it. No, it's not great. The immediate.
Oh my God, sorry.
No, it's cool. We're all about dogs behaving and having to train them. So anyway, Bruno, what I'm going to teach you is that if you have a Sunshine Law claim, the best defense to raise is freedom of speech. Oh, they I'm not sorry, not freedom of speech, but right to privacy. Sorry about that. If someone brings up the Sunshine Law, the legislator will bring up, oh, well, under Florida, I have a heightened right to privacy. So that conversation shouldn't be publicized. However, that argument will likely fail because in Florida, the Sunshine Law gives a right of access in these situations. So you should train yourself to be able to write arguments and then failing counter arguments. The one reason why people get 50s and not 80s is because they only write about the correct answer in a tunnel. I need you to take detours, not frolics, right? I need you to take detours and write about other counter arguments, opposing arguments, potential arguments if you had additional information. That's the way to really get a heightened score. If you're someone who's taken the California bar or the UBE, you're not really familiar with that because in those states, they really just want you like, just the facts, Your Honor. Florida is one of those states that really wants you to elaborate. Okay, so we have the Fourth Amendment, we have the Fifth Amendment, and then last but not least, does anyone know what the Sixth Amendment protects? Right. Go ahead.
Right to counsel for indigent?
Sorry.
Right to counsel?
Yeah, and someone said they're still confused because First Amendment requires government action. I can sue in defamation as a private action against a news agency. Yeah, I mean, a lot of times it is government action on these exams. Like it'll be like a sheriff or it'll be like a newspaper that's reporting about a mayor. So that's a good point that the Constitution only protects against the Constitution only protects against governmental intrusion, not private action, whereas defamation is usually a private claim. So that's a good point. I'm just trying to get the wheels turning that like First Amendment, defamation, have similarities. The main similarity is just that singular sentence that the First Amendment doesn't protect certain types of speech, including defamation, also including obscenity, false or misleading commercial speech, words that are likely to incite loss, imminent activity. So great question. And then Angie, excellent point. I said, what's the Sixth Amendment about? And she said, your right to counsel once formal charters have begun. Absolutely. Distinguish between the Fifth and the Sixth Amendment, right to counsel, and the Sixth Amendment is after adversarial proceedings have begun. Also, your right to a speedy trial, right? That's going to be a Sixth Amendment, also the confrontation clause. What's mostly tested on con crim is Fourth Amendment. I think warrants, and when there's an exception to a warrant, and I'll teach everyone the spaces mnemonic eventually, either later today or in my course, but exceptions to warrants, when you need probable cause, it's usually like Tommy's smoking a suspicious smelling thing, and then they grab it, and then they search his phone, and then they find out this plant, and like, it's just, at what point have they violated the Fourth Amendment, or has there been a exclusionary rule violation or fruit of the poisonous tree doctrine discussion? Those are things that are pretty heavily tested. Okay, let's see what this PowerPoint's got in store for us. So Florida approach versus the federal approach. These are the main slides. Florida approach means that when you get a con law essay, there's three lenses: a Florida lens, a federal lens, and the con crim lens. The Florida lens really wants you to consider these things. The Sunshine Law, first one, that's your right of access. You have a right of access to Florida where if legislators are discussing something, the public has to know about it. And we'll get into detail over my course. This is a, very quick essentials course. I'm actually going to switch over to property in just a few minutes, but like, just know that the Sunshine Law, if you can write down one thing, is a right of access for the people for public, say, correspondences. Homestead exemption. Anyone here have a home? Own a home in Florida? Erica, do they have the homestead exemption in New York? The homestead exemption?
No, so they don't have a homestead exemption in New York. They don't have anything like that, at least not that I know of, from when we owned our house there. But they do in Florida. You have to register by a specific date for it to count for the entire year. And you have to live here, and this has to be your primary residence. And that's how you get your homestead exemption, and you register it with the county. And sometimes you'll also register it with like the city where you're in.
And what's so cool about a homestead?
Doesn't raise your taxes. We'll go with that, but it's more so from a creditor's perspective. That Florida is a debtor-friendly state. So if you are getting sued or there's something that's happening against you individually, then they can't actually take your house. There are obviously certain thresholds to it. Don't ask me about it because I don't remember offhand. I'm sorry, I'm blanking on that part, but there are certain thresholds. Some of them, for example, is like if you're head of household, it's a higher exemption amount than if you're not head of household. But ultimately, a creditor can't make you foreclose on the house unless they're like the mortgage company or something like that.
Yeah. So in Florida, there's homestead exemption has two prongs. The first part is its protection from judgment creditors, which are people who are trying to collect on a judgment and include your house. They can't collect your house in that judgment unless they are one of the super creditors. And as she mentioned, that's like taxes on the house or improvements on the property, like a mortgage or maybe construction lien or mechanics lien or some type of homeowners association lien or anything involved on the property itself. It protects your actual home. The other piece of the homestead exemption is a tax deduction. You could take up to $50,000 off the value of your home, because it's in your primary residence. And you're right, it's got to be half an acre in a municipality or 160 contiguous acres outside a municipality. So that's the homestead exemption. So as long as you understand from today about the Florida approach, sunshine law is the right of access, homestead exemption is protection of your home, and a tax deduction, that's a good start.
I have a
General law,
question about,
yeah,
I'm
go
so
ahead.
sorry.
Go ahead.
The homestead exemption, the home itself has to be in an individual's name, right? Like it can't be in a trust and then get a homestead exemption against, let's say, judgment creditors. Is that right?
Yeah, think of it really as an individual protection measure. It could be the father, the mother, even the kid potentially, but it's not gonna be like something that's not individual. So that's a good question. Okay, so general, special, and general law of local application. Quickly, a general law is a law that applies to the entire state. A special law is a law that applies to a particular county. And a general law of local application is a law that applies based on population. So a general law of local application does not need a vote, whereas a special law does need a vote, a referendum. And then a general law is just a law that applies uniformly throughout the state. And again, if these things are going over your head, I'm going to discuss everything in further detail. This is just introduction. Chartered versus unchartered counties. In Florida, we recognize chartered counties, which give municipalities under the home rule power the authority to enact laws or ordinances that do not conflict with the Florida Constitution. Enacting a law or ordinance in Florida. So to enact a law or ordinance in Florida, certain requirements have to be met. It has to have an enacting clause, be it enacted in the state of Florida. It has to have a clear and concise title, Corn Growth Length Act. That's a terrible title. Length of Corn Stalk Act, right? And it has to have a enacting clause, a clear and concise title. It has to have a single subject. I mean, it can't be about the length of corn stalks and also about, a curfew. It can only be about one singular subject, and they like to test that a lot. It can't be vague or overbroad, and it has to relate to the health, welfare, and morals of the people of Florida. This is tested a lot, powers vested to separate branches of government. I'm not going to go deeply into it, but just know that you should understand encroachment, usurpation, entanglement, entwinement, stepping on the toes of another branch. What the executive branch, legislative, and judicial branches are allowed to do is confined, and if there seems to be something fishy on an essay, you should approach it. Vagueness and overbreadth tested very often. A law is vague if you don't know what's being punished, and the law is overbroad if it's punishing more than intended. So if it restricts legal and illegal behavior, it would be overbroad. And then the Kluger Doctrine, this relates to access to courts. We should understand that access to courts is the concept that you should be able to have redress and go to court if you've been wronged, and they shouldn't restrict that. Under the Kluger Doctrine, they can restrict that if there's a public necessity. So again, like I was saying earlier with, First Amendment versus defamation, or right to privacy versus sunshine law, and having an argument and then maybe a weak counter argument. With access to courts, the counter argument would be Kluger Doctrine, that you can restrict access to courts if there's an overarching public necessity. All right, cool. So federal common law approach, we talked about a lot of these things, briefly, but always start with standing, injury, causation, redressability, see if there's been state action. And that's what Ian was alluding to, right? And that's why you can't just have like a singular mindset, like, oh, defamation, I'm going to talk about X, Y, or Z. You have to see what's going on in the fact pattern. But if the fact pattern does involve state action, that's when we'll talk about our constitutional framework. And so again, there has to be state action, not private action, but there could be some entanglement for sure. And there has to be standing, injury, causation, and redressability. Has to be right but not moot. These are familiar concepts I'm not going to go too deep into, but we should know and understand. Due process, we talked about due process and the difference between procedural and substantive due process. Procedural, does anyone remember what procedural due process, 2 words associated with it? Sleepy Joe, Sleepy Tom, would be two words associated with procedural due process. Does anyone remember?
One of them's notice.
Yeah, one of them's definitely notice.
Notice and hearing.
Yeah, notice and hearing. Amazing. And then substantive due process. Does anyone know the difference between substantive due process and equal protection? I can tell it's early in the administration. The difference between
Sorry.
substantive due process and equal protection. Go ahead, Cassandra.
Doesn't substantive due process apply when you have like a government license or like government, like issued property that's being taken from you?
Potentially, I'm more asking like, in a nutshell, substantive due process is when everyone's rights are being deprived, whereas equal protection is when a specific group is being targeted. So an example I would give would be like, everyone has to wear a mask during COVID. Whether or not I agree with this or whatever, there's an argument that that's a substantive due process violation. The government is, depriving everyone uniformly of their right to whatever you want to argue. Whereas an equal protection argument would be like, all men have to wear the mask, or all women, or all people of this particular group, right? So the difference between equal protection and substantive due process is substantive due process is a deprivation of all people's constitutional rights, whereas equal protection is targeting a specific group or group of people. Cool. So we talked about First Amendment. So does anyone know? Does anyone know what 5 things are guaranteed by the First Amendment, or some of them?
Freedom of
Free speech, freedom of religion, freedom of assembly. Nope, sorry. Go ahead.
Go ahead, keep going. You're doing good, Robbie. No, this guy, Robbie. I like you said, let's say it again, Robbie.
Freedom of speech, freedom of religion, freedom of assembly, freedom of association. Is that same or?
That's part of freedom of
Freedom of
religion.
the press.
Okay.
Yeah. Okay, freedom of religion can be boiled down to freedom of association and freedom of assembly. Or establishment, I'm sorry, association and establishment, my bad. Freedom of religion can be free association and free establishment. The 5 main tenets of the First Amendment are freedom of speech, freedom of religion, freedom of the press, freedom of petition, and freedom of assembly. Right. And then we talked about kind of what types of First Amendment speech are not protected, like false or misleading commercial speech, or defamation, obscenity, or words that are likely to incite imminent lawless activity or even hate speech. So Fifth Amendment, we already talked about those 5 things. Cool. You can see it now with your own eyes. 14th Amendment, equal protection, suspect classes. So you definitely want to be comfortable talking about strict scrutiny, intermediate scrutiny, rational basis. In Florida, strict scrutiny is going to apply to race, alienage, national origin, and does anyone know? I'm like an elementary school teacher. Yeah, disability and disability. Let's try to keep it lively. Yeah, and disability. That's a distinction between federal and Florida. In Florida, disability is actually subject to strict scrutiny. So is the right to work is fundamental, contraception, the right to marriage, the right to procreation, right to educate your child, right to raise your family, privacy rights, anything under the Constitution, access to courts, these are all strict scrutiny rights. Intermediate scrutiny would apply to like gender or legitimacy. And then rational basis applies to everything else, age, wealth, anything like that. So Commerce Clause, Dormant Commerce Clause, privilege and immunities, not heavily tested on Florida essay, so kind of skip it. And then Commandeering Clause, encroachment, state sovereignty, sovereign immunity, all again, federal concepts that I'd like you to know. I'm not going to go over tonight, but they're good things to know. And then we talked about the con-crim approach, 4th, 5th, and 6th Amendment, reasonable expectation of privacy, probable cause, warrant, stop and frisk. I'll teach everyone the mnemonic that I think is cool. Spaces stands for, well, it's a mnemonic, doesn't stand for anything, but spaces is a mnemonic to remember when you're considering exceptions to the need for a warrant, right? S stands for search incident to arrest. P stands for plain view doctrine. A stands for automobile exception. C stands for consent. E stands for exigent circumstances. And S stands for stop and frisk. Can someone write that in the chat if anyone caught that or everyone knows that, so that we can, for the slow writers in the room, right? S is search incident to arrest. P is plain view doctrine. A is automobile exception. C is consent. E is exigent circumstances. And S is stop and frisk, like a Terry stop. Cool. You see how we should just know how to speak about these things. I always say that if you could teach something, you can really be confident that you know about it. So I want everyone to just kind of listen to me and think, hey, I could do that too. I can know what the spaces mnemonic means. Okay, so murder, arson, conspiracy, inchoate crimes, theft crimes. These are not heavily tested on essays, but they could test them. And you want to be over prepared. Okay, so we talked about the sunshine law, the right of access. We talked about the homestead exemption. I'm just gonna run through this so I can go to property, but just know you can go back to this PowerPoint and learn all these things. Sunshine law, homestead exemption protects the half acre or the 160 contiguous acres. Enacting a law, I talked about all these things. Adequate title, enactment clause, relate to health, welfare, and morals of the people, not vague or overbroad, single subject. And then passing a law in Florida, read 3 times. Passed in both houses, that's called bicameralism, to pass in the House and Senate, title, single subject, and the governor's signature. Florida does not recognize a pocket veto, little tidbit, whereas that is recognized at federal law. General law, special law, general law's local application, I kind of went over these things. Access to courts, we need approval of 60% vote to change things to the Florida Constitution. And about special sessions, these are special sessions that can be called by the governor, but they have to be confined to what they were called for. Talked about fundamental rights, compelling interests. You definitely need to know the definitions for strict, intermediate, and rational basis. We talked about takings. And then, does anyone know who the second president of the United States was? I ask this question every year. It always amuses me. Does anyone know who the first president was, at least? I'm just kidding. But does anyone know who the second president was?
Isn't it one of the Adams?
It was. Which one do you think it was based on that correct fact? If it was the second president and George Washington was the first, do you think it was? It was.
Was it John Adams?
Yeah, John Adams. Yeah.
It's John or Sam, Sam, right? John.
Yeah, John was first, and then Quincy came fourth. I believe, actually. I might be wrong, actually. Okay, so real property PowerPoint. So does anyone have any questions about con law in general? It's not easy. Con law is a very tough subject. There's 3 different lenses you need to know. I think sunshine law and homestead exemption are particular Florida particularities. You want to be confident in 4th, 5th, and 6th Amendment, 5th Amendment, 14th Amendment. Know that 5th Amendment and 14th Amendment have been incorporated, and via reverse incorporation, they apply to federal and state action. So you don't really need to get caught up in that. Just be consistent with it. Start with state action. Here, the issue is whether there's state action, blah, blah, blah. The next issue is whether they're standing. There needs to be injury, causation, redressability. The next issue is whether Tommy, whether the law impacts Tommy's First Amendment rights. Just be very diligent about arguing as much as possible. They typically tend to test the same things. It's usually an act or ordinance that is unconstitutional. Maybe it wasn't enacted properly. Maybe it violates constitutional rights. Maybe it's vague or overbroad. Maybe it violates due process. Just have a toolbox of constitutional arguments and argue as many as you can. We'll definitely get back to con law, but we're gonna move to real property, which is a very tough subject. But I have an old PowerPoint. This is one of my first OG PowerPoints. Not that OG, 2021. 2017 was the OG years, 2018. So what day is it today? It's today, Squeak Piglet. My favorite day, said Pooh. That's a very stoic way to live. I think actually Winnie the Pooh is one of those cartoons that if you look back on, you could learn a lot from, maybe that's a stretch, but I think that the author was, actually, I don't know anything about the author, but I don't know, I like this cartoon right here. It's very stoic, like just treat every day like it's a good day. You're blessed to be here. Sam made a really great point, like you're studying for the Florida bar exam. You made it already. You already are a JD. I have a friend who's actually in the room who just got a badass job at a wealth management firm doing compliance, and she really doesn't need to pass this test. Now it's just a cherry on top. Like just having a JD is a awesome thing. We're just getting the cherry on top right now, and you get to hang out with me. How fun is that, right? I have hilarious jokes. Okay, so here's the real property outline. Some things that we want to talk about: deeds and titles, estates and property interests, joint tenancies, covenants and equitable servitudes, landlords and tenants, easements, adverse possession, homestead exemption. There we go. Crossover. Allen Iverson. Who else would get crossover these days? Kyrie Irving, right? Miscellaneous, and then essay writing tips. So not that easy. A lot of it comes down to vocabulary, which is a hard part of real property, vocabulary. And that's just the way it is. I want everyone to be comfortable writing about mortgages. I want everyone to be comfortable writing about Florida being a lien theory state and what the implications of that may be. I want everyone to be comfortable writing about Florida being a pure notice jurisdiction and what the implications of that are. And then, yeah, some of these things, a landlord tenant, pray for a landlord tenant essay, you know, like you've all been in that situation. You know what you should argue for. Real property essays can be tough to put together because there's usually like a conveyance and then a party that commits waste and then a party that records the deed improperly and there's no notice. Like it's usually a shit show because it's a made up situation and they just want you to slowly but surely talk about what issues you see and go from there. I'm not going to sign the essay that I took February 2017 because that would be brutal. I think it was like the hardest essay ever. Like, nah, it was one of them. There've been some hard essays, but I encourage everyone to look at it. The February 2017 real property essay. If you look at the model answer, this person literally just did the IRAOC, issue rule analysis, opposing argument conclusion. And it read like very mechanical, which I don't encourage. You know, I like a little bit of flair, a little bit of artistry. It was very mechanically written, but it does demonstrate like that's kind of the mechanical framework of a great essay is doing the issue rule analysis, opposing argument conclusion format, and just, you know, methodically addressing the issues at hand. All right, this is me. I don't even have a picture. Oh yeah, Rosie and Biscuit. You've heard from them. Rosie's coming over right now. What's up, Rosie? I can't show her. Okay, so deeds versus title. What's the difference between a deed and a title? The difference between a deed and a title is that a deed is a document that purports title, whereas title is a position of ownership. You could potentially have title without a deed, right? Via adverse possession, for example. So deed is the document that purports title. Color of title versus actual title, what does that mean? Well, color of title is when you have a title document and then you take like red, blue, or yellow crayons and you draw. Zero laughs. So color of title. Oh, I got one. Nice. Thank you, Cassandra. Okay, so color of title means appearance of title. It's like when it seems like you have title, like you have a document that purports title, but that document is faulty. Maybe that document, it's like that movie Benchwarmers, right? It's the paper that says I am 12, but the kid was like 20 years old. Like you do have a document that says you're 12, but you're really 20. You have color of being 12, but you're not 12. That's what color of title means, appearance of title. So why would you have an action to quiet title? Well, if there's a situation where multiple people are there's a conflict over title. Tommy and Johnny both have documents that purport title. Let's have an action to quiet title, and we'll quiet Johnny and be like your document is trash, and we're going to go with Tommy's document, and that we're going to quiet title and determine who actually has title. Deed formalities. This is something you can just remember. In order for a deed to be valid under Florida law, it must be attested by 2 witnesses and contain an accurate description of the land and be properly delivered. In order for a deed to be properly delivered, physical delivery is not required. It just needs to it just needs to be out of the control of the one person. So if I deliver a deed to Tommy and say, here, take this deed, but give it back to me if the Dolphins win the Super Bowl, then, you know, it's not actually delivered. And if you're not a Dolphins fan, like some of our prep instructors are, and you had a mean joke there that like, it is never going to happen. We're not going to go that route. We're going to say that the deed hasn't been delivered because if the Dolphins win the Super Bowl, you can get the deed back. So it hasn't left your control. It has to truly leave your control to be delivered. Okay. Pure notice jurisdiction. They love testing that Florida is a pure notice jurisdiction. Pure notice jurisdiction means that bona fide purchasers will prevail. All right. Done, right? No. So bona fide purchaser means someone who takes without notice for value and in good faith. So they weren't gifted it unless they take via the shelter rule, which means someone downstream of a bona fide purchaser. But not to get in the weeds here, just know that a BFP is someone who takes for value without notice in good faith. The key piece there is without notice. There's different ways you could have notice, which would not make you a bona fide purchaser. You could have notice via actual notice, like you literally knew. Let's say that we're talking about notice of like Tommy having an interest in the property, and Tommy is a farmer, right? If Tommy literally has a farm on the property and I go there and see Tommy like milking the cows, I have actual notice of his interest. Like I literally saw him. That's actual notice. I also have what's called inquiry notice. Why do I have inquiry notice? Because a reasonable inspection of the property would have put me on notice. So I can't just be like, hey, I have no notice because I never saw the property. Like, no, you are supposed to inspect the property and do a reasonable inquiry. And then there's also record notice. Record notice means that you should have checked the county records. It was in the county records. Record notice and inquiry notice are types of constructive notice, whereas actual notice is a type of actual notice. That's a tough concept, but just try to remember that Florida is a pure notice jurisdiction, as opposed to a pure race jurisdiction or a race notice jurisdiction. I don't really need to explain them because Florida is not them, but just know in Florida, it doesn't matter when you recorded. It just means that whoever's the last bona fide purchaser, they're going to prevail. Whoever took the property for value in good faith and without notice. And I just explained the different types of notice. Marketable title will always assume marketable title. So that means that the property doesn't have any encumbrances. It's free of easements. It's free of claims of adverse possession. It's free of threats of litigation. It's free of weird zoning ordinances. Just anything that makes it like not good. Like some things can be unmarketable. Okay, so tax deed. In Florida, a parcel of real property becomes eligible for tax deed when ad valorem taxes become more than 2 years past due. So you can pretty much pay the taxes on a property and get a tax credit that shows that you've paid for those property taxes. Not to get lost there, just remember what titles and deeds are all about. Title is a position of property, as a position of ownership, whereas deed is a document that purports title. It needs to comply with deed formalities. Florida is a pure notice jurisdiction, and all conveyances have an implied marketable title. In all conveyances, there's the implied warranty marketable title. So types of deeds. If you see a deed, you should talk about the types of deeds. I'm not going to get too deep into them today, but there's general warranty deeds, there's special warranty deeds, and there's quitclaim deeds. General warranty deeds are the best types of deeds. They come with the 6 warranties, the 6 covenants, the present and the future covenants, the present covenants of sizing, the right to convey, and the right against encumbrances, and then the future covenants of quiet enjoyment, general warranties, and then further assurances. So you should memorize those 6 covenants. You should spot them. You should talk about them. I'm not going to get too deep into them, but just like have that discussion. Like the deed was a general warranty deed, which means that it had these 6 covenants here. Because there was an encumbrance on the property, it likely violated the covenant against encumbrances. it's kind of a hard thing to discuss, but just know that if you're talking about deeds and you mention the different types of deeds, and then you mention the 6 covenants of a general warranty deed, you're doing pretty well, right? Like, it's a tough test. Easements and property interests, I kind of skip over this slide, but you know, you do have to have a basic understanding of real property, that real estate transactions conform with the statute of frauds, that there's concepts such as fee simple determinable, fee simple subject to condition precedent, and fee simple subject to executory interest. They're not heavily tested on Florida real property. That's why I don't have my MBE presentation here, because they don't really test like estates, but they could. And so you do just want to have an understanding of these concepts. This has actually been changed to 1,000 years now. Joint tenancies, this I feel like you guys had a discussion about this yesterday. JTROS means if Tommy and Johnny have a JTROS and Johnny dies, then Tommy will inherit the total of the property. A joint tenancy with right of survivorship, we need to have time, title, interest, and possession, those 4 unities. So you want to be familiar with that conversation. Tenancy in common is Tommy and Johnny, your tenants. If Johnny dies, then Johnny's heirs, Johnny's estate, will take his part of the property. That's the assumed type of tenancy. A tenancy by the entirety is a JTROS with marriage. In Florida, we've abolished the need for a straw man. A straw man is a third party who allows you to have the unity of time between married parties to convert a JTROS into a tenancy by the entirety. Florida has eliminated the need for a straw man. If that went totally over your head, don't worry, but it's just a little point that you could get. I'm trying to teach people how to write 70, 80 plus essays, and it's just the more you know, the more you can articulate, the better you'll do. I know that this is a tough day, right? I see the yawns out there. It's almost done, don't worry. Con law and real property are really tough subjects. This is just an essentials introductory course. If you're just getting some little fragments, just know you're ahead. And when I teach these things in detail over the complete course, it'll make more sense. Covenants and equitable servitudes. I live in Coconut Grove, and in my little homeowners association thing, we all have to have blue doors, right? That could either be an equitable servitude or a covenant, but it's a condition on the property, a promise that my door has to be blue. How do we know if it's a covenant or an equitable servitude? It's likely an equitable servitude. Why? Because if I paint the door red, they're going to force me to paint it blue. The remedy will be equitable. Now, what if the thing was like you can't have a motorcycle parked in the parking spot, and for every day that you have a motorcycle parked there, you have to pay $50? That would sound more like a real covenant, because it's remedied by legal relief. Technically, an equitable servitude is a type of real covenant, but they tend to distinguish them as equitable servitudes are remedied by injunction and real covenants are remedied by monetary relief. Landlord tenants. So this slide I'm not going to go too deep into, but this is what you're praying for on a essay. There's some essays that are literally just like Tommy is the landlord, Johnny is the tenant, Johnny is like partying, Tommy is like partying as well, and major party, windows shatter, and bad things ensue. Who's liable? And then you'll just have a conversation about like habitability, quiet enjoyment, duties for the landlord, duties for the tenant. And it's just kind of like a methodical conversation that you could have via experience. Because I feel like everyone in here has been a tenant before and has had a tough landlord, and you know about like, you know, constructive eviction, holdover tenant, and these different factors. A mnemonic, I know we all love mnemonics, that I think is interesting here. That's the word I use, is your period will suffer. That's how you remember the different types of tenancies. Tenancy for years, which is just for a specified period of time. A periodic tenancy, which is like month to month, or, you know, week to week. And then tenants, your period will, a tenancy at will, which means either party can release at any time. And then a tenancy at sufferance, which is like a holdover tenant. The waste, this is a key piece. They love testing this, waste. Tenants can't commit waste. And it also applies to life estate holders. They can't commit waste. Actual waste, also known as voluntary waste or affirmative waste, is if you like punch a hole in the wall, right? Permissive waste is like you let something rot. You see something rotting and you don't fix it. And then ameliorative waste is still waste. It's like there's a essay where this lawyer owns or she's renting a property and she builds a little office building on it. Well, she didn't have permission to do that. It's still waste, even though it may have benefited the property, it's still considered waste, and that's not okay. Easements, you should really be, everyone should know about easements, right? That's when you have a right of access over someone's property, express, implied, by necessity, right? Like you have to access a public road. Prescriptive easement is a lot like adverse possession. It's where you've just had this right of access so long that you've established a right of way. Prescriptive easement is 20 years in Florida, whereas adverse possession is 7. Easement appurtenant is their dominant and serving estate. Easement engross is like it benefits the party personally. It doesn't run with the land like a utility company. And then a negative easement, Florida doesn't have doesn't recognize a negative easement for light or air. That's how we know the famous Fontainebleau versus Eden Rock case, where they built the spite wall to block their sunshine, and there's no right to have the sun land upon your property. But there are riparian rights. Riparian rights refer to water rights. Your right not to have your water restricted. If I have a house on the water, my neighbor Johnny can't put a dam and restrict the water from flowing to me. Adverse possession, a good acronym is OCEAN: open, continuous, exclusive, actual, and notorious. So, that's squatters' rights. We should all understand adverse possession. If you just squat on a property for long enough, then you could have title to that property. It's not so easy in Florida because you can claim under color of title or without color of title. The key is without color of title, appearance of title, you have to have paid property taxes. Homestead exemption we talked about. Miscellaneous, some key things. Florida is a lien theory state, so in Florida, an encumbrance on the property is with the person, not the property. So if the person dies, the party, the debtor can't foreclose on the entire property. A lien theory state means that a lien, a debt on the property will not sever a JTROS. Risk of loss. So Florida follows equitable conversion. So if Tommy and Johnny execute a contract, and during that period of escrow after the contract, but before the sale, the risk of loss actually shifts to the buyer. So if there's a fire or something, the buyer will be responsible for that loss. Eminent domain we talked about, that's the takings clause. Public nuisance, again, private nuisance is a tort. Public nuisance has, just considerations. That's like the attorney general saying that you're doing something that's really bothersome to the entire community. And then nuisance abatement is not a valid public purpose for which eminent domain may be properly exercised. So we have some selected answers here. This is the one from 2017 that I was talking about. Yeah, that's the presentation for today. I know it was a lot, trust me. I know going over my con law PowerPoint and my property PowerPoint and even going a few extra minutes was a lot today, but I'm just really trying to give everyone some exposure to the things we're going to talk about. So your assignment will be to write a con law essay and a property essay. Last week, it was the contracts and the torts essay. And then the last week of the essentials course, it will be Florida multiple choice subjects. Next week, we'll have class for Florida on Tuesday and Thursday. And then the MBE class meets tomorrow. And then it meets one more time next week on Wednesday. And then the following week is when our complete courses start all the way from the beginning. And we'll really get after it. So I really appreciate everyone spending their nights here with me. And Sam, as always, you did an amazing job.